Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning. Our first case today is Southern Tactical Range versus Gartman, number 2025-1259. Whenever you're ready.
May it please the court. Alan Lawson on behalf of Southern Tactical Range LLC and BITN LLC. This case presents a very narrow question. Does Section 82316 Florida statute violate Article 1, Section 21 of the Florida Constitution, the access to courts provision? Before we begin the analysis, I'd like to address a poll-star legal principle that should guide your decision in this case. And it's from an opinion that Justice LaVarga penned, City of Fort Lauderdale versus Dar. And as Justice LaVarga stated, in all constitutional challenges, the statute comes to the court clothed with the presumption of correctness, and all reasonable doubts about the statute's validity must be resolved in favor of constitutionality. That principle was overlooked by the First District in its decision, and it should guide your decision today. 82316 is a narrowly tailored liability protection statute in favor of sports shooting ranges that allows them to operate without being bankrupted and put out of business. It's very narrowly aimed to protect them against suits.
Could it have been more narrowly aimed if it had been an affirmative defense rather than a form of total immunity from suit?
Justice Coriel, I don't believe so, and that's not what the legislature chose to do. Either way, I mean, in order to protect gun ranges from liability that would bankrupt them, you have to protect them from suit under some circumstances, at least for noise, because it is an inherent.
That's my point. Under some circumstances, that's not what the statute does. The statute protects them from lawsuits under all circumstances. So while the statute comes cloaked, there are things the legislature can do to denude it of its presumption of correctness. And one thing, like your opening argument, is that one thing it can do to denude itself of that presumption is to sweep more broadly than it might. And it seems to me that in this case, it is not a sort of a barrier to certain types of claims. It is a full stop barrier to any accountability at law. Tell me what I'm missing.
So that characteristic, it is not an immunity from suit. It's a conditional immunity from suit. In other words, it only applies with respect to noise if the gun range is in violation of a noise ordinance that was in place at the time that the range was built or came into operation. With respect to all other claimed nuisances, they were litigated here, and the statute does not preclude suit against them. So it is very narrowly tailored.
Does that basically mean then that does it basically work like an affirmative defense, essentially saying that we, the legislature, are going to defer to the local governments on how they're going to do their noise thing and apply it here, and if you're complying with that, those criteria at the time that you begin operation, basically the balance of rights between the property owner and the gun range is going to be kind of settled by whatever the substantive law of that ordinance is at the time.
That's correct, and it's very similar to, it's an adjunct to, or very similar to, this is essentially a land use problem. The public policy concern is a land use problem. Where are we going to allow sports shooting ranges to locate and operate in the state of Florida. And the property here was zoned to allow them, and property across the state is zoned to allow them, and under state law, that is a local decision. But that zoning is not enough to protect them from going out of business for lawsuits due to an inherent characteristic. And so it is exactly like that. I mean,
so is it, as a matter of sort of background law, is it right that compliance with local zoning laws, just in general, is not kind of it's not sort of a conclusive defense against a nuisance suit?
That is correct.
Okay.
Yeah.
So basically, if we're looking at it through the Article 1, Section 21 lens, it is changing sort of the background principle in that sense. Right.
Correct, yes.
So it's kind of supercharging whatever. I mean, I'm assuming compliance with the zoning would be relevant in a nuisance suit, but it just would just be part of the mix that the court would be looking at.
Exactly, yes.
So the constitutional provision speaks to any injury. So you have access to the courts for any injury, for redress of any injury. First of all, do you acknowledge that noise can be a nuisance on one property to another, that it is?
The common law recognizes it as a potential nuisance.
Correct.
Claim, yes.
So in this particular instance, generally speaking, the property owners could sue someone for nuisance, for a noise nuisance, right?
Yes.
Okay, but they can't recover for injury. If they proved it, they could not recover for injury caused by this kind of defendant for noise.
That's
right?
correct.
So how is that it's really not just a matter of just qualifying the cause of action. It's eliminating a particular type of injury that can be recovered from a particular defendant that they could recover from someone else.
That is correct, yes.
Right.
Does your client have a position on whether the Gartmans could have sued individuals using the range, shooting, creating noise?
That has never come up. They never tried to sue individuals, but the protection for the range, in order to be effective, would have to cover individuals who are using the range.
So that's another source of the potential nuisance that you would say this statute sweeps into immunity.
Yes.
Is there anyone then, to follow up on Justice Tannenbaum's question, that could be a source of recovery for this common law remedy, or for this common law protection that you've acknowledged exists?
Not for noise. Under the circumstance where the property is zoned for a gun range and is not in violation of the noise ordinance that was in place when it was put into operation.
So how is it then that where are the plaintiffs to go? So if they can prove, so we establish, if injury is defined as an infringement of a right, of an established right, and so they have a right to quiet enjoyment of their property, and they allege that they are suffering some infringement of that by noise, which has been acknowledged to be a type of injury to their property, where are they to go for redress of that? It's certainly not the courts, apparently. So
that's correct.
How do you reconcile that with the constitutional protection?
The only recourse that they have is through the local government prior to a range operating. That is correct.
Well, that would be for a permanent nuisance. I mean, presumably they could go to local government and try and get some ordinance change to stop that or to rezone it or whatever. Where are they to go for the injury they've already suffered, the temporary nuisance? Like, so, noise has already interfered with their enjoyment. Where are they to go for redress for that? That
question goes to the threshold question that's set forth in Kluger versus White, and that is, when is this right triggered? And what Kluger said is it applies when the legislature abolishes a right of action or total abolition of a right to sue. And under this court's precedent, that does not occur here. There's no total abolition of a right to sue under a State versus Roberts decided in 1980. In that case, at common law, a spouse had a right to sue to invalidate a prenuptial agreement on the basis that there was no full and fair disclosure of wealth prior to the signing of the agreement. And the legislature abolished that ability to sue for that reason. And the court said that that was not the total abolition of a right to sue, because you could still sue to set aside the agreement for other reasons, and those other reasons included mental incapacity or a coerced signature or a forged signature. Now, I would submit that the most likely reason why someone would sue to set aside the prenuptial agreement would be because there was no full and fair disclosure, not because it was coerced, but that was abolished, and the court would essentially have to recede. I don't see any way around from Roberts, would have to recede from Roberts, because here you can sue in nuisance for, and it happened, for a number of other conditions. Here they sued, the Gartman sued for smell, for shaking, for gunpowder residue, and you still have a right to sue for noise under the circumstances are set forth in. So there's no way you can call this a total abolition of a right, even though, just like in Roberts, the plaintiff there could not sue alleging what she otherwise would have alleged at common law, that she was not given a full and fair disclosure of the wealth of her husband before signing the agreement.
Well, it seems like the problem is it's a problem of generality, like how much what level of generality are we going to apply here? So, I mean, a cause of action, there's a title or it's a chapter in a tort book, it would be headed nuisance, and Blackstone has a chapter, headed nuisance. So maybe at that level, sure, the complete silo of nuisance has not been eliminated. But if you look at it from the perspective of the Constitution, it speaks in terms of any injury. A smell nuisance might be a different injury than a noise nuisance. And so in this respect, it seems like the plaintiffs have lost the ability to recover damage. If their injury is solely because of noise, they can't recover for that.
Right, and that is essentially, if you take Roberts and you put the facts there and just substitute the facts here, they match identically. And you can say the same thing about the spouse in a state of Roberts. She, at common law, had a right to sue. She was injured because she was not told about, and her husband didn't disclose wealth before he had her sign a prenuptial agreement, and she lost the right to sue. But if you do decide to recede from Roberts, we would still prevail. I'm going to go to the second Kluger prong first, given the amount of time, and that is that the legislature can abolish a right of action. So if you believe that there's a total abolition of the right to sue, which we submitted there isn't in this statute, the legislature is able to do that if they establish an overwhelming public necessity.
Can you talk about methodologically how we arrive at that conclusion? Our precedent seems to look to the statutory text for the legislature's reasons for passing the law. Do you think that's what we do? Is there something else that we look at when we're determining whether or not there's an overwhelming public necessity?
This court has never inferred a reason. I think you could very easily infer the reason here from just looking at 823.16. What they have required is a statement that justifies the legislation. And sometimes that's in terms of findings, it usually is. Sometimes it's in terms of a policy statement. In this case, you have both in the statutes.
Can I ask, isn't it on this prong, isn't it fatal, though, to your argument that the legislature is basically deferring to local governments? In one place you could have a super strict noise ordinance that would make it almost impossible to run one of these things. A place like this, they're exempted. I mean, if it's really an overwhelming public necessity, how can the legislature then sort of be agnostic as to what the actual ordinances are going to be and whether these gun ranges happen or not?
Well, it is. The legislature said it's an overwhelming public necessity, and they haven't been agnostic. They could have, and I think they could have said no suit for noise violations at all. And the fact that they didn't do that they gave folks a way to live in a place that they would be protective from noise based on gunfire from a sports shooting range means that they more narrowly tailored this this statute to address the public necessity.
It seems like if there really was, you would think that the legislature itself would come up with whatever the rules should be. You know, I mean, I'm not. It's like I'm not criticizing the legislature for arguably being more reasonable or more federalist or whatever you'd want to call it, but it just seems like it's inconsistent with the idea of an overwhelming public necessity when you basically delegate the ultimate decision making to the local governments at the end of the day.
I think there are two responses to that, and maybe the second is that it really is an adjunct to local zoning laws, and that by statute is the province of local government, so it makes sense that they would do it that way. And the first is that that what matters is that the fix matches the problem. That's what, under that second prong of Kluger, the court looks at. And here, the fix matches the problem because it allows sports shooting ranges to exist and operate and not be bankrupted, and it protects the public in allowing them to sue in other ways, and protects them from noise based on local noise ordinances and local zoning laws.
Can we ask you just about Kluger in general?
Yes.
So if you look at, you know, the Article 1, Section 2 right about having a right to enjoy property or whatever, that if that were the provision at issue, it could be a reasonable regulation. It could be regulated reasonably, right? Mm-hmm. Here you have a situation where you basically have two landowners who have rights that are in competition. You've got, you know, each of them wants to use their land, you know, in a way, the range wants to use their property in a way that's arguably going to harm the other property owner. So these are tough calls that the legislature or the local governments have to make. And normally courts would kind of defer on that. Does Kluger really work? I mean, in the sense of, you know, why shouldn't sort of the substantive rights that are in competition here just be subject to reasonable regulation, just the way they would be if it were directly under the Article 1, Section 2 right? I'm just wondering how you get past Kluger, but Kluger itself seems like maybe it's not a sensible approach to this area.
It is less deferential to the legislature than perhaps it could be in terms of meeting the needs of the people of the state of Florida. And just in the short time that I have left, in 793-33, the legislature found that this provision, or the sports shooting ranges, were a necessary component of the exercise of the Second Amendment right, that they were essential for public safety in a number of different ways. Law enforcement trained there. In this case,
why should we import that into a different statutory section when they weren't passed contemporaneously?
Okay. Because your case law compels it, and that I'll cite. There are a number of cases, but Florida Highway Safety and Motor Vehicles versus Hernandez, statutes relating to the same subject must be read together. That's a must. That's a direct quote.
Don't we apply that in the context of statutory construction and determining the meaning of the words of the statute rather than essentially what this case law is asking us to do, which is the reason, the intent that the legislature passed it? How does that track into legislative intent realm?
Well, legislative intent is, in my view, sort of a shorthand for the words and what they say and what you can glean about the policy of the state and the operative provisions of statutes from those words. And what this court has said is that in doing that exercise, especially when you're trying to determine what the intent is, what the state law is trying to accomplish as it's set forth in the words adopted, you look at all related statutes. And that is a clear command. Florida Department of State versus Martin. Courts are required to read statutes together, especially, and this was in Hernandez, especially when we're dealing with constitutional claims. We want to make sure we get it right. We read them together. And Martin is when you're trying to determine what the intent of the legislature again, what do these statutes mean? These statutes are more than closely related. They are inextricably intertwined, and here's why. First, the policy statement was unnecessary in 793.33 for any operative provision. The legislature can curb the state in any way it wants to without justifying it. Article 1, Section 21 doesn't apply. However, that policy statement cannot be fulfilled. The policy of the state will not be fulfilled without 823.16. It is the operative provision that primarily fulfills the policy statement in 790. They are inseparable. And if you look at the text, this is one of the mistakes that the First District Court of Appeal made, and I'll just, in the time I have left, I'll go through all four. One, they said that in pari materia was only used to clear up ambiguities. That's not the case. That's not your precedent. Two, they said that 793.33 does not address private lawsuits. And if you look at 793.33(1)(I), it finds that unnecessary litigation and unnecessary regulation by government threaten to destroy the industry. Now, if you apply the normal rules of grammar, the post modifier by governmental agencies applies only to unnecessary regulation. In other words, if you just apply a normal grammar rules and the rule of last antecedent, all litigation, including private litigation, threatens to destroy the industry. The legislature is assumed to understand the books that are already on, the statutes that are already on the book. And so in giving their private...
I'm sorry, counsel, I don't mean to interrupt you. You have one question, and then you're already all through your
So to pick up on the
chief.
Chief's point, talking about regulating rights as opposed to eliminating a right, it sounds like part of your argument, you're not saying it this way, but it sounds like underlying that is making a distinction between a private nuisance and a public nuisance, and perhaps you're looking at it from the perspective of the legislature has determined that for this, the noise is odd, it's different than some other types of nuisance because noise goes everywhere, and so the public in some way bears some of that burden, and Blackstone makes a distinction between that. If this were reclassified as a public nuisance, that seems to help your argument, wouldn't it? Like, if it's a public nuisance, then the legislature can regulate it, and now we don't have the same problem with one person suffering injury without recourse. Now it's a public matter. Agree, disagree?
I agree, but under the statute and under Kluger, it does not matter because the statement of public necessity, overwhelming public necessity, can only be fulfilled if private individuals cannot sue a gun range for the noise that it is an absolutely inherent characteristic of its operation. In other words, it cannot operate without creating noise. The legislature says we have to have them in the state, and they have to go somewhere.
Okay,
and they can't.
Sorry to interrupt you. You can have 2 minutes for rebuttal.
Thank you very much.
Yeah. And if you need a couple of extra minutes, obviously you can.
We'll find out. May it please the court, Charles Bell with my co-counsel Mike Chester on behalf of the appellees here, Eugene and Adrian Gartman. From the very day this gun range opened, my clients were powerless to do anything to stop the gun range or to take care of their noise problems, which have rendered their property virtually unmarketable.
Can we talk about the second prong of the Kluger test?
Sure.
Same question I had for opposing counsel. Methodologically, our precedent asks us to look for the legislature's reasons.
Sure.
My problem with that precedent, and it's nowhere explicitly stated that that's what we have to do, but that's what the precedent seems to have done, is not only are we now constraining through our precedent the legislature's ability to pass substantive law, but we're also telling them how they have to write the laws, because if they don't give their reasons, then we assume they don't have one. How is that consistent with the judicial role? Can you defend that as an original matter?
Sure. I mean, first of all, this has been, the courts always assume the legislature understands the law, right? So, I mean, when Kluger was enacted, it was passed, it was decided in 1973. So we've had over half a century now where the courts understand that if we want a law to violate a right of access to courts, one way we can do it is to show an overpowering necessity.
And I'm not talking about whether they understood that that case existed. I'm just saying, as an original matter, can you defend that from a separation of powers standpoint?
Sure. I mean, I think there's always, courts always look at the legislative intent to see if the legislature can do that. We do that in the federal system all the time with strict scrutiny. So anytime that the Congress in the federal system passes a law to determine whether it's constitutional, if it affects a constitutional right, the Supreme Court for decades and decades has applied strict scrutiny and looked to see, is there compelling interest? How do they do that? Well, they can do it by showing it, but they can also do it by what the legislature points out. This is a compelling interest. We have to do something to protect these individuals here, and that's what's going on here.
For you to win, I mean, we could tweak to the extent that if anybody thinks that we're saying the legislature has to explicitly say X, Y, and Z. I mean, the bottom line is if you treat this as a de facto compelling interest kind of review, they can say it explicitly. We can infer it. I mean, I think in this case, the fact that the government's not even here defending the statute, I mean, that's kind of telling. I mean, so it doesn't seem like for your purposes you don't need to really tie yourself to like one particular way of enforcing that part of Kluger, if that's legitimate, if that's correct in the first place to even be asking that question.
I think that's exactly right, Chief Justice, and I think that's because there's simply nothing here. They've conceded, in fact, that when this statute was passed in 1999, it did not satisfy the second prong of the Kluger test because there was no finding, there was nothing in that statute.
Well, you just said, I mean, you just told the chief that you don't think there need to be a finding for it to satisfy the second prong of the Kluger test. If we're looking at it as like a typical scrutiny, how courts typically analyze constitutionality of statutes.
Well, they look at the underlying reason behind it, but they do in fact look for findings, and that's what this court has done for years. And I recognize your point is that should we have done that? But that has been the law in this state for over half a century. In fact, probably in other contexts even longer. So we do look for what the legislature wants, and they know how to do it, and they've done it dozens and dozens of times. So it's not like they don't know how to do it. In fact, they did it in 790.333. They included findings. We would not be here if the legislature had made similar findings and said something along the lines of this is a compelling interest or an overwhelming public interest necessity that we abolish this right.
So you think we can't infer them? You think there has to be express findings, and that we can't do what we typically do in a constitutional analysis, which is, as our precedent says, give the legislature essentially the benefit of the doubt.
This court's precedent has always been we look to see what the legislature said, and they don't have to say there's no magic words. We recognize that, for example, in 790 they didn't use the word overwhelming, but I don't disagree with the concept that if we were here arguing over whether projectile environmental issues were immune from governmental action, which counsel says is not even necessary to get there, then they didn't use the magic words. But we agree that those statements were important, and they do sufficiently justify that particular restriction.
So can we focus on the first part of the Kluger thing? So to follow up on what Justice Tannenbaum was asking about, it seems like the sort of the starting point for the analysis is what is injury,
yes,
right? And that's going to be defined in terms of people's kind of legal interests,
yes,
right? And it seems like it's inevitable that there's going to, there has to be over time, and Kluger itself talks about this with society changing and all this. I mean, there has to be some flexibility, it seems, for the legislature to be able to kind of, within reason, sort of adjust, rights this way and that way. Why isn't that subject to sort of a reasonableness type analysis? And then the question maybe should be, in this case, let's assume that you're right, that it's taking, it's trimming back a baseline from the injury that you would have had in the absence of a statute. But the legislature is basically saying, look, this is complicated. People need to enjoy their property. On the other hand, shooting ranges are important. We're going to defer to the locals to kind of work this out on what people can live with noise and whatever. And this is where it's going to settle. I mean, why? I understand that if we agree with you that that the quote unquote, the injury is sort of set in stone, in 1968, and the injury was defined a certain way. And I understand the abolition point, but it seems like the Kluger test might be kind of. I don't know that it's compelled by the text, and it seems kind of out of sync with the sort of the needs of a complicated society where there's always going to be friction between people's rights.
And that's true, but that's also true in the concept of workers' compensation and no-fault laws, other areas where the legislature has in fact sort of abolished the access to courts, but set up some alternate scheme or something of that nature. They didn't do that here. So again, my clients at the time this was passed, because Okaloosa County did not have a noise ordinance. So they've never, from the day that shooting range opened, there's nothing they can do.
But the question, I think, just to pick up on where the chief was going, so if we start with the word injury, which actually appears in the constitutional provision, the question is who, and if injury is an infringement of a right, we have to identify, well, who gets to set the right? Like who establishes the right in the first place? Presumably it could be in the Constitution, but then besides the Constitution, I'm assuming it would be I'm not assuming, I know, it's going to be the legislature, which is the maker of substantive law. So if the legislature can define rights, and then the infringement of which would be an injury, isn't there friction again? So there's this conflict between the idea of who's defining the injury. The Kluger seems to bake into it or beg the question about what injury is. It just assumes that there's a cause of action, so that equates with injury, and so you can't abolish it. Shouldn't the legislature, under the Constitution, have the ability, the flexibility to orient or reorient the interface of rights between competing landowners? You have one landowner that they're zoned to use it a certain way, and they're using it the way it was zoned, and you have another landowner that is complaining about that, and their complaint, the effect of which would be to put them out of business. Like let's assume there's no way for them to operate a gun range without some noise, and so they're always in peril of being sued. Can't the legislature step in and regulate that and redefine the right in a certain way, not eliminate your right to enjoy your property, but regulate this conflict between two property owners?
I guess I have two answers to that. They can, but the legislature is always constrained by the language of the Constitution, and that's really what Kluger recognizes. So, in other words,
yeah, but the Kluger doesn't actually look at the text. It looked at the CJS, and it's a provision that had no citation. That's the basis for their conclusion on all this.
Understand, but the Constitution does talk about redress for any injury, and that's what the Kluger test focuses on. So, in other words, if the legislature wants to do what to have that sort of play in the joints and make some regulations here, they have to first of all make sure they do not violate the constitutional right to access to courts, which allows redress for injury. And if they're going to do that, then the regulations have to be narrowly tailored. They have to be important, to be overpowerly
so basically,
overpowering public interest.
So your textual connection then is to say that it sort of locks in injury. If this was adopted at a specific time, injury then is going to be defined by whatever the rights are that you have at that time. And if you're going to take away redress for that injury, then it has to meet a compelling interest test, basically. But then does that mean, though, that because Article 1, Section 2 directly talks about your right to enjoy property, et cetera, et cetera. And if we were looking at it from that perspective, that would be subject to reasonable regulation. But then if you look at the same concept in the access to courts provision, it's not subject to reasonable regulation. Does that make sense?
I'm not sure about the first part, but the second part makes perfect sense.
I'm pretty sure the first part is right.
Yeah, the first part is right.
If it weren't, then everything would be unconstitutional.
Sure, I understand that, but this court has been, again, Kluger's nothing new as the court is aware. It's been around for over half a century, and it's been applied consistently for the half a century. There's not been much debate about it among the DCAs or this court. And again, the legislature has a lot of flexibility here. They can do a whole bunch of things, and this court has allowed the legislature to do a lot of those things. They can set up an alternative remedy, which they didn't do here. they can find it to be an overpowering public necessity to do this.
Don't you think it kind of
it
constitutionalizes, the test constitutionalizes the common law in the sense that, like, now the common law is a more protected form of law than statutory law, because the legislature can change statutes for whatever reason, essentially. But if it's this common law, now it's been kind of put at the same, almost a higher level than those rights in the Declaration of Rights.
I recognize that Kluger does essentially
It doesn't make
bake
a
in
lot
the
of
common
sense,
law
though, right?
rights.
I mean, from just the structure of the Constitution, we have legislative power, we have the Declaration of Rights, we have enumerated rights, and then we have what from the text looks like a essentially equal protection clause that's now been used as the way to cut off the legislature's ability to pass substantive law.
And I recognize that, and I think that's where Kluger basically says that rights that existed as of 1968 are sort of baked into the system, and you can't infringe upon that. And again, that's been the law, and the legislature knows how to get around this. They know what to do. They know if they wanted to enact this law, they could have included findings to talk about how important this is. They could have tried to come up with an alternate system. They could try to narrowly tailor it to sit there. How can we make it harder for someone to prove a nuisance claim?
But why should the legislature have to do that? I mean, so in 1968, I mean, this provision is not a new provision. I mean, it's been in existence in one shape. You know, I mean, the first DCA opinion actually has a table that shows the provision going all the way back to 1838.
Yes.
So in 1968, there was no magic to the revisions. The people adopted the Declaration of Rights, and they also readopted Article 3, which vested all legislative power in the legislature. It seems odd from an originalist perspective to suddenly assume that the people intended to freeze out the legislature from ever regulating, you know, a certain set of rights, even rights that they established themselves through the adoption of 2.01, the Florida statutes. It just seems like an odd approach to the text.
Well, and perhaps, but again, the constitutional language is plain, and the people voted this Constitution into office, and it basically into being, and it says essentially that, you know, the legislature cannot restrict the rights for people to seek redress for particular injuries, and Kluger used the word particular injuries.
Which is what gets back to, it's begging the question. You're just like, you can't just gloss over injuries. It's, well, what is the injury, and who gets to define it? Apparently, in Kluger, they said, well, I guess the courts get to define it, and we already defined it, and the legislature is powerless to do anything about it, even though the legislature adopted the common law and said, like, until abrogated by us.
Sure. And I recognize that.
And us being the legislature.
No, and I recognize that as well, Mr. Justice. But I think, you know, again, I'm defending Kluger because nobody's questioned Kluger. I mean, I understand this court can overturn precedent. I understand that concept. But the gun range hasn't asked you to overturn Kluger. And again, the Attorney General didn't even show up in this case. Not below, not at the first DCA, not here. So we're talking about a law that's been settled for, you know, since 1973, that's been applied faithfully, that no one has really questioned. And because it's been applied faithfully and not questioned, I think because in practice it doesn't doesn't tie the legislators' hands in ways that are problematic, because they know how to get around it. And
Under the existing
forever.
test, under the existing Kluger test, can you address, and I appreciate the exchange between the inference and express findings on the last prong of the Kluger test, but can you address, assuming we took the inference approach, can you address kind of the amicus briefs, if we're going to infer reasons that the legislature might have for limiting nuisance or noise lawsuits?
Yeah, and I mean,
why aren't the reasons laid out by the amicus brief?
And I think, you know, going back to the inference issue, I think the reason is because it's got to be something overpowering. But again, yes, clearly the legislature have an interest in protecting gun ranges, or they would not have enacted the statute in the first place. But that's the difference between trying to protect gun ranges and finding this to be so essential that we have to do this. We have to restrict that right, and they didn't make that finding. And in fact, even when they made that finding 5 years later in Section 790.333, the thing that they say we need to read together, the legislature included a specific provision in 5B that says, quote, "Nothing in this act is intended to impair or diminish the private property rights of owners of property adjoining a sports shooting or training range." So even when the legislature made express findings, they still said, we're not talking about what happens to your neighbors. We're talking about only what happens with the government in that sense. So at no time has the legislature ever suggested that shooting ranges have to be immune from suit as an overpowering public necessity. I mean, again, they had a reason to enact the statute in the first place. I don't think anybody disputes the legislature wants to support gun ranges. I don't think that's a problem, and I think that's a public policy that the state can make. The question is, how do they do that consistent with the language of the Constitution?
Well, could we infer that the legislature was trying to reclassify, recharacterize a private nuisance into a public nuisance under particular circumstances?
I think that would be stretching the inference a little bit too far, because the legislature knows how to say what they want to say, and they understand how to include the right language. So if they wanted to make this a public nuisance, they would have said that.
Well, they
Those
did
things aren't
with the
mutually
ordinance.
exclusive anyway. I mean, that public and private nuisances aren't mutually exclusive. So I mean,
I would agree with that point. So,
Do you concede, just as a basic matter of first principle, that providing a space for the exercise of Second Amendment right can be overriding or compelling interest for purposes of Kluger analysis?
I think it could be. Whether it is, I think it could be. But again, we have to sort of, when the legislature wants to show an overpowering public interest, they say so. And I think that's the key point.
I mean, we've been having this discussion this morning.
Sure.
One could argue that they did say so. I don't think you need a statement of legislative purpose to say that the purpose of a statute is contained in its text. That's indeed how we, sort of interpret texts in the first instance. We don't look past the text, right? So I don't know that you can say the legislature didn't make a statement of purpose. It acted.
Well, it acted, but the legislature acts every time it passes a statute. So, in other words, if that's the sort of the analysis, then every time the legislature does something and changes the law, then we have to assume, well, they had a good interest, therefore it's constitutional.
Isn't that?
We have to assume it had an interest. In fact, we don't assume at all. We know that it did. That's the way textual analysis works.
Yes, and that's it. But the question is whether that interest is so overpowering that it has to essentially take away the constitutional right that my clients had. And again, this court would not. You can't find an overpowering public interest in doing something by silence or by implication or by possibility. If
that, I think, is a heavy burden for you to take on. I don't know that. I don't know that you need to shoulder that. You've now conceded that the Second Amendment right could be that compelling right.
Yes.
And I don't know that a statute is made more or less constitutional by a recitation in the whereas clauses of its purpose.
Well, but this court has always looked for that because, and they've told the legislature, look, it's sort of an open secret. If you want to make this pass constitutional muster, this is what you do. I mean, it's essentially a roadmap this court has given the legislature, and they have taken advantage of the roadmap.
It seems pretty obvious, though, that there's skeptics about the roadmap. But the bottom line is, to call this a compelling, I mean, in any sane understanding of compelling interest, there's going to be a record. There's going to be something for the court to look at. It would be kind of comical in this context with no record and with a statute that basically punts to the local governments. You could have any possible outcome depending on what's going on in different places. To say on this record that there's a compelling interest, to me, seems kind of absurd. But on the first prong of the Kluger thing, it seems like maybe that's absurd too. I don't know.
Well, I would agree with both of them, Your Honor, both points you make, Your Honor, in that regard. And I think that the First District did unanimously, and for that reason, we would ask you to affirm the decision of the First District Court of Appeal and give my clients the right to pursue their redress for their injuries based on noise caused by this gun range. Thank you.
Thank you very much.
Any created test that does not tether itself to the language of the Constitution that it's applying a test for is dubious to start. I agree with that. And we haven't challenged Kluger and asked you to overrule it. And that is very simply because there's just no question that as this court has applied Kluger and given the clear precedent from this court, this statute is constitutional. And I say that not only because of the presumption of constitutionality that was never applied, but also because of the in pari materia doctrine. counsel is correct that your precedent does require the legislature to make those findings, but they are here, and the only reason why they were avoided is because the First District Court of Appeal, ignoring your precedent, said that we're hesitant to look to a later enacted statute to determine legislative intent.
Can you say a little more about the question you were exploring with Justice Sasso earlier about how the in pari materia doctrine and the other sort of doctrines that you invoke in this vein are sort of semiotic? We're using them to, generally speaking, determine the meaning of a word. Here, there's no dispute about the meaning of a word. We're not. It seems inapposite. Why would we use a tool that is designed to fix the meaning of a word? That's why we use that canon to answer the question in this case where there is no dispute about the word of anything, the meaning of any word.
Well, your precedent has used the canon beyond that, and it says it's always to be used. You always read closely related statutes together to determine, quote, legislative intent. And legislative intent, again, that's what we're trying to get at it. And it's not, as my colleague on the other side says, what were 160 Florida legislators thinking in 1999 when they enacted this statute? Legislative intent is what is the policy of the state as it expressed in the body of statutes that we're looking at today.
Yeah, I mean, it's a coherence issue.
Yes.
I mean, it's the reason why you would look at a later enacted statute to try to figure out the meaning of a prior enacted statute. It couldn't be because of intent, because of the timing, but it lends the overall coherence. And so I think the idea is you'd read them together so that, if the legislature thought there was a compelling interest in one area, then maybe a closely related area, maybe you would infer the same thing.
That is correct. And two last things. One, in 795B, the statement that this statute isn't intended to alter any rights that exist today. 823.16 was already on the books, presumed to be constitutional, had never been challenged, and so what the rights that existed 5 years after that statute were passed did not include a right to sue a gun range that was not in violation of the noise ordinance at the time that the gun range was operational. I would just say that this court has long championed separation of powers, and this case at its core is a separation of powers case. The 823 is constitutional, and the First District Court's decision has put an overwhelming public policy necessity that the legislature declared at risk by making all gun ranges in the state, even though it uses the words as applied, the way that they decided this case, they have invalidated the statute. So any gun range can be put out of business and bankrupted, and threatening our Second Amendment rights and the public safety of the people of the state of Florida. We'd ask you to reverse. Thank you very much.
Thank you very much.
Good morning. May it please the court.
Sorry. Let me do our thing here. So now we're doing Thorpe versus Memorial Sloan-Kettering Cancer Center, number 2025-1004. Sorry for interrupting you.
Thank you. I'm eager. Good morning. May it please the court. Carol Link. It's my privilege to be here and to represent Honorable Janet Thorpe as petitioner. I'd like to reserve 5 minutes for rebuttal. Words matter, and the Florida legislature chose broad words. They're not narrow, they're not limiting, and they don't have exceptions. And the Florida legislature chose broad words to convey who is subject to Florida's long-arm jurisdiction. The issue before the court is governed by the de novo standard, and it's narrow. This issue is whether Section 48.1931A 6B was met by my client's second amended complaint's allegations and the plain, obvious, and common sense meaning of the broad catch-all words that the legislature used. Applying this court's...
But you wouldn't say that the complaint was well manufactured. Your brief was excellent, but I wouldn't say it was well manufactured. Right?
Would I say my brief was well manufactured? It was processed. It was definitely a process. And one of the things that occurred in the 6th District Court of Appeal, and I'm glad I wanted to say to the court that we're here for two reasons. The 6th District Court of Appeal found issues with the Second Amendment complaint with regard to the temporal connection and with the word serviced. It's a footnote in the opinion from the 6th District Court of Appeal. And there was discussion at oral argument. I want the court to know two things. The temporal connection was never addressed, never raised in the trial court before Judge Netcher. Judge Netcher granted the motion to dismiss. You will not find that argument of at or about the time of injury in the motion to dismiss. If you read the hearing transcript before the trial judge, it was not addressed. It was addressed at the 6th District Court of Appeal. So I asked permission to amend the Second Amendment complaint to add it. But we do have sufficient allegations in the paragraphs 50, 53, and 56, and I can discuss that. But Justice Curiel, to get to the processed issue, it's really interesting because
Don't we read that word in the context of the other verbs in which it appears and understand from it that we're talking about making stuff as opposed to analyzing stuff or interpreting stuff? It would seem that again, now in this case we are engaged in a meaning-making exercise, and we're trying to decide whether this cluster of words together connotes a type of conduct that involves what the doctors did in this case, sitting in New York.
Right.
And I struggle to think of a common user of the English language who would say that the doctors sitting where they were in New York manufactured or processed these. I can imagine a statute that said if they write, analyze, consider, that we would be reaching for that. But help me understand the concatenation of words here as reaching an expression of medical conclusion in a written analysis.
Sure, thank you. Two things. Number one, it's broad. It's broad.
But it's not indeterminate. So,
okay.
I hear you saying it's broad, but let's put aside. Let's focus on the actual words here.
Absolutely.
Because words have to be determinate, right?
Absolutely.
A term has to exclude something.
Correct.
Or else it's not a term.
Good. That's correct. And the three words that are used are intended to reach more than just traditional manufacturing of goods, because you're right, they're things. It has to service or process or manufacture a thing. And the 6th District Court of Appeal had no problem reaching the understanding that the MRI report is a thing. So the question, or the answer to Your Honor's question, is in the actual word processed. It's a transitive verb. And the 6th District Court of Appeal went to Merriam-Webster's dictionary and said, process means subject to a special process. Well, if the English language is not my first language, that doesn't tell me anything. So if you use Merriam-Webster again, and you look up the word process, because that's how it's defined for the transitive verb, the term process is a series of actions that produces something and leads to a particular result. That is a report from an MRI. That is a tangible thing that is processed by the doctors in New York that then is used by the Florida doctors, and that's how you get there. It is a processed thing.
As a footnote here, have you argued that the doctors in Florida, I don't know if you argued this below, were in any sense agents of the doctors in New York?
We did. We absolutely did, for the purpose of vicarious liability. And that was, I think that was argued also at the hearing before the trial judge.
How did the report cause injury?
The reports were used in Florida, so that's that temporal connection.
But how did the report itself cause injury to your client? And the reason I asked is that you sort of just jumped ahead. You made a statement that, well, this is broader than just covering products liability, which my understanding is actually that was the origin of this provision. So how do you make that jump, and can you tie it to, okay, how does this thing that was made, and just taking I'm not saying I agree, but just take your concept, made in New York,
used here,
and comes to Florida, used in commerce, and caused injury to your client.
Right. In paragraph 50, Your Honor, the written reports and analyses, which is the exact same term as the Dean versus Jones case, same term, written and analyses. You don't go to the...
well, that's why we're here. I mean, yeah,
right, absolutely.
That's
They contain diagnoses and recommendations that were then used in Florida. Those were negligent.
Yeah, but those are thoughts. Those are abstract concepts. Those are things that the doctor did in New York and then reduced it to writing.
Correct.
How did the report itself? I mean, this is a little bit, I guess, maybe the question is a little bit facetious, but I'm assuming the report itself did not jump out and injure your client.
No,
it didn't explode or anything like that.
That's right.
And why can't we read the statute more in the context, or these terms, in the context of what the long-arm statute is trying to do? And when you read all of this together, it does sound a lot like, well, a outside, out-of-state manufacturer of a product sends it into commerce, it comes to rest, and they know that it's going to come to rest in Florida and be used in Florida, and something happens in the course of that. It explodes, or something deficient in that manufacturing causes injury to a client or someone in Florida.
They're deficient reports, so they're used by the doctors in Florida.
Well, the report accurately reflected what the doctor said, right?
Well, the MRI showed new mass in the groin. It showed new osseous lesions, and it's not clear from the Second Amendment complaint whether the report was accurate, not accurate. What's in the Second Amendment complaint is the report is here. The doctor calls and contacts the physicians here, discusses the recommendations and the diagnoses, and the argument is, or the pleading is, that those diagnoses and recommendations were deficient. Had they been non-negligent, had they been fulsome, then my client...
But that's not the report. That's the diagnosis. No, the report reflects the diagnosis.
Well, the report...
That's the problem with this. So you're going to focus, and you're going to use the word thing to hang your
That's the narrow
hat
jurisdiction
on.
that
But
I'm
the
hearing.
thing is the actual physical document, the report, which does nothing other than to reflect some abstract concepts that someone's put in.
But isn't the way the statute works is that you're subject to personal jurisdiction for any cause of action arising from any of the following acts, and then it says causing injury to persons or property within the state arising out of an act or omission by the defendant outside this state.
Right.
So here, that's the act that we're talking about. And then the jurisdictional thing is if at the time that you caused that injury from out of state, something that you had processed, serviced, or manufactured was being used within the state. So I don't know that this is saying that the report has to be the thing that causes the injury.
The injury is the injury. The use of the report has to occur at or about the time of the injury.
I think, well, the causation of the injury. So I think it's, so there's the causation of the injury from outside the state.
Correct. Right. That's
and then
correct.
At the same time, so that's sort of the tort. And then at the time that you have done that, are there products, materials, or things processed, serviced, or manufactured by you that were used or consumed within the state in the ordinary course of blah, blah, blah.
Right.
Right. So they're like two. So I don't know that it's connecting that the injury itself has to stem from the report. I think it's like you kind of have contacts with this. You have enough. And then you get to the constitutional thing, which sounds like maybe if the report had nothing to do with the injury or whatever, that maybe that would be the reason you would lose. But it seems like here you've got sort of the what is the thing, what is the tort that you committed? And then what are your contacts with the state of Florida that might subject you to personal jurisdiction? And so I think you have a serious problem with the manufactured process service thing, but I don't think that you have a problem with the fact that the report itself didn't, bite the plaintiff.
No, but the report itself came into Florida. It is an act or an omission by the defendant outside of the state in New York, so I can check those parts. It causes injury to my client if at or about the time of the injury, the report was serviced outside anywhere, so it says outside in New York, it's used in Florida in the ordinary course and scope. I think I said in my brief that this syntax for the sentence would drive an English grammar teacher up the wall with frustration, or Strunk and White would be frustrated with it. But I think coming from a textualist standpoint, these words must have meaning. And so I'm not trying to parse them too specifically.
Can I ask a hypothetical? Just
yes,
because I'm trying to figure out where the lines would be if this is how we interpret it. If a New York lawyer drafted a will, had paperwork for a client, that client came to Florida, requested his file, which had a mostly finished draft of a will, finished in Florida though. Right. Florida lawyer signed off on it. Client dies, massive will issues. Would the New York lawyer be subject under Florida law with issues, assuming under this type of thing?
So the New York lawyer drafts it, there's an omission or an act.
It doesn't even draft the full thing, just has, a draft. It's finished in Florida, but the document is prepared. It's wrong.
Right.
It's sent to Florida at the request. It's used by a Florida lawyer. It's finished.
So the injury occurs, or it's at or about the time of the injury. The will or the document is used here in Florida. That's what, so I think yes, and when I go through my diagram that I have here on the statute, as you were speaking that through, it does fit within those. It's a thing. It's processed outside the state, and then at the time of the injury, I guess the injury being the harm to the estate, the beneficiaries, it's being used in Florida.
So it would seem that your kind of interpretation, if that would encompass it, would be incredibly broad. Where would the limits be of something that was done out of state? Where would be the kind of boundary you would set then?
I think the second part of the Venetian salami test then comes in. You have to have the sufficient minimum contacts. So does this lawyer know that the will is going to be used in Florida? Are there contacts? Are there phone calls to the co-lawyer in Florida? How many times, and what is the
So your idea is
purposeful?
The statute is huge, and then it's restricted by the other issues.
Minimum contacts.
Yeah.
What about same facts? Same facts as this case, our case, except instead of a written report, everything is done orally.
Everything is done orally. And is the, well, we do know from, and I don't want to talk about cases that aren't cited in the briefs, but the Internet Solutions case, we know that you can have a defamatory statement, right, that comes into Florida. We know that telephone calls.
But let's stick to this case.
Okay.
There is
and so it's just a doctor making a phone call?
Instead of transmitting a written communication, the identical communication is transmitted orally. Is that a thing for your analysis?
I think, well, for this analysis, I think if that were my...
Or it's sent by Slack and it disappears.
Well, is it a product, though? I mean, it's a product, material, or thing.
It's not a product, it's a phone call. So
Okay.
I think I fall under subsection 1A2.
So for
under
you,
those
the
circumstances.
jurisdictional analysis then can turn on whether this communication is reduced to writing or not.
It does. I mean,
Is that a sensible constitutional line?
Well, it gives meaning to the words in the statute, Your Honor. And I have to argue this because our jurisdiction that was granted by this court was narrow. I dropped a footnote in my brief and said if you want to talk about other avenues that we pled below or that we argued below, we be happy for supplemental briefing, because I think what you're talking about is committing a tortious act within the state, which is higher up in that specific jurisdiction within that statute. So, but I have to give meaning to the words that the legislature used. We're not redrafting, we're not rewriting, and a thing is absolutely a report, a medical report. It absolutely was processed in New York, which is anywhere, and then it is used in Florida. And
Do you acknowledge that if there were no long-arm statute at all, like if this statute would never pass, that the court would have no jurisdiction over the defendants?
If we
the
had
out-of-state
no
defendants, the
yeah,
doctors
I
in New
think
York.
that's correct, yes.
So you acknowledge that. So the purpose of a long-arm statute is to provide legislative authorization for court jurisdiction over an out-of-state defendant that otherwise wouldn't exist.
I would agree.
Right?
That's correct.
And so that's what we're dealing with here is, did the legislature authorize a court to exercise jurisdiction over a defendant like the doctors here on the basis of
That's
a
right.
medical report that they produced in New York?
That's correct. Yes, I agree with all of those statements, Your Honor. The Florida doctors here relied on these negligent prepared reports, and they contributed to the malpractice and the poor treatment of my client's daughter here in Florida that caused the injury. So, and that temporal connection, I just want to just touch on that for a second, or regroup on that. The temporal connection is an interesting phrase. It's at or about the time of injury. That's pretty broad. So if this court finds, if I get past that first things processed, and then you're concerned about at or about, paragraphs 50, 53, and 56 connect those, because they say the reports were used in Florida during the course of treatment, and the treatment caused the injury. So the use of the reports causes the injury, at or about. I've got it. And by the way, with cancer, there isn't a specific date, right, of injury. You've got an injury, you've got malpractice, you've got a doctor who missed something, you've got reports that come here, you've got an evolving injury. But she absolutely, and we have pled in those 3 paragraphs, that the treatment, by using those negligently prepared reports, caused her injury.
Right. Well, so the legislature does the authorization to reach out, and the way the statute is worded is it's basically constructive. It's so a defendant is deemed to have submitted him or herself to the jurisdiction of Florida courts if they do one of these acts.
Right, correct.
And presumably, it seems to me, we read the whole statute, the legislature is kind of doing a trade-off. Look, if you're going to take advantage of the protections and benefits of this state in some way, then you're submitting yourself to jurisdiction. And here are all the different ways that you can take advantage of the protections of this state within the territory.
Correct.
So I'm having a hard time understanding then how a doctor in New York who, in the course of practice, just examining someone in New York, the person happens to be from Florida, and reduces that his diagnosis to, in a digital form or some sort of report that then gets sent in some way later, how that doctor is
held liable here.
is taking advantage of the benefits and protections of Florida law.
Okay.
That then would submit him to jurisdiction.
Well, that's the second part of Venetian Salami.
It's the second part, but it's also the first part, because the legislature adopted the long-arm statute to be coextensive with constitutional protection. So it's odd.
It's coexisting.
You're kind of doing the same analysis twice, but I think it's important to look at the statute and the text of what it's doing. And I don't think you can gloss over it and just sort of do this abstract application. So the
but
question
it's not
is,
abstract. I mean, the problem is if you either you do or you don't meet the statute. But it's not crazy to think that, sending your products, materials, or things that you processed, serviced, or manufactured anywhere, you send it into Florida and it's being used in the ordinary course of business. There's nothing crazy about, and then obviously in the particular case, you may need to then get into the constitutional stuff with step 2. But
the due process, the second part of Venetian Salami.
These things are broad.
They are broad. And the First District Court of Appeal and the Fourth District Court of Appeal found exactly that. The facts of Dean in the First District Court of Appeal, the Second District recognized all relevant facts are the same as the facts that we have here. They simply got caught up on the word processed, the 6th District got caught up on the word processed, and they got caught up on the at or about the time of injury, which I've demonstrated those 3 paragraphs meet. But
you can,
it is,
you can
I am out of
finish
my
up
time.
and then have 2 minutes more.
Okay, I appreciate that. Thank you.
Thank you. Good morning, Your Honors. Attorney Gerard Collins from Kaufman-Dolowich. I have the privilege today of representing the respondents, Memorial Sloan-Kettering Cancer Center, and Sun-Hyung Yoon and Sin-Chun Huang as the respondents in this case. As the court is aware, this case is before the court on a conflict jurisdiction between the 1st TCA and the 6th TCA. It is our position that this court should approve of the ruling from the 6th and disapprove of the ruling from the 1st for the following reasons. The plain language of Chapter 48, Section 193 Florida statutes does not encompass the mere authoring of medical reports. The statutory context and the legislature history and legislative intent support the product's liability analysis in this case. The Thomas Jefferson case is distinguishable and does not support extending the statute for purely intangible outputs like reports. The Dean case is factually distinguishable on all fours.
Counsel, can you just address? There seems to be a discussion here over what level of abstraction should we apply? Should we read the language in this statute? So, one level, and one can read it more narrowly, and it sounds a lot like a product liability provision.
It does.
At another level of abstraction, broader, it can include anything. Things could mean anything, and process, by one definition, could mean what has already been discussed.
Yes,
so
that's correct.
How do we choose which level of abstraction we should be looking at the statute at?
Sure. The court is correct. We're looking at products, materials, and things. Those are our 3 nouns. And processed, serviced, and manufactured. Those are 3 verbs. The 6th TCA came to the conclusion that ultimately the MRI report is a thing. And the word thing is perhaps the most overbroad word in the entire language, English or whatever language. But it is too much of a catch-all. And as I will get into, when we are interpreting statutes, we have to use the plain, the ordinary, and the common terms. And to the extent that a certain term is overbroad, and to the extent that you have to labor to force it to mean a certain thing, then that shows you that that word is overbroad and is inapplicable as it is in this case. So I think that that is overall the argument that we have on the actual text of this of these 6 words.
So you're saying that thing is going to be limited first by the 2 nouns that precede it, and then the 3 participles that come after it.
Correct, and all three of those things and all 6 of those words have to be read in conjunction. We're looking at a product, a material, or a thing that is processed, serviced, or manufactured.
Isn't the right answer to this question about what level of abstraction to use context? I mean, you just use the word thing to describe an abstract sort of concept, like a part of speech. And in the context of that discussion, it makes sense for us to understand thing to mean a concept. But in the context of these words, where we're talking about products and their transmission, it makes sense to give thing a more concrete reading. Is that a fair argument?
Absolutely, and especially the word manufacture. Manufacture connotes assembling things to make a different object, a washing machine, a dryer, a toaster, an automobile, something like that. Manufacture does not apply to the abstract thought process of taking your analytical ideas and putting them into an output product.
I wanted to ask a question that takes us in a whole different direction, so if we come back to this, sorry.
Sure.
Would you concede that the cooperative research agreement that your client signed constitutes purposeful availment of Florida?
No, I would not, Your Honor.
How?
It is a limited It is a limited purpose document for the treatment of one patient.
How is its limited purpose make it any less of an availment of the hospital with which you contracted to do the research? I don't understand. If I for a very limited purpose, if I negotiate a share purchase agreement of a New York corporation and I'm buying the assets of one New York corporation, the New York Times, you're telling me that I'm sorry, that's just one availment of the of New York. You didn't
Well, I think that's a different that is a different set of facts. In that scenario, you have more of an ongoing concern, whereas in this particular case, we're involved in just the treatment of one patient. And that is what is factually distinguishable, I think, from this case and the Dean case from the first. In this case...
Does your client engage in any marketing in Florida?
Not that I'm aware of, Your Honor, and certainly at the time of all of the events, that was not the case. So none that I'm aware of. But here, in this case, we have very clearly, we have a New York hospital. We have the hospital with no medical licenses, no offices in Florida, no agents in Florida. Dr. Yoon is a New York licensed surgeon. He's practicing exclusively in New York. He does not have a Florida license. He does not have a Florida office. He did not solicit Florida patients, and there's not even a claim of solicitation of Florida patients. Dr. Huang, the radiologist, again, a New York licensed radiologist, no Florida connections, and there were no proactively...
What about the data collaboration agreement? Is that not more ongoing?
The
Exhibit B to the petitioner's Second Amendment complaint is a data collaboration agreement and an alliance relationship agreement with Baptist Health South Florida. Is that not more of an ongoing contact?
I think certainly going forward that may be more of an issue, but at the time of the events that are the subject of our case today, that was not the case. So I think that is a tangential issue that does not specifically involve the facts of this case.
And that would be more of a question of general jurisdiction, right?
Yes, sure.
Whether can an individual be subject to general jurisdiction of the state? Or is it limited to that concept? Is that limited to corporations that don't have a physical existence?
Certainly that is one of the possibilities in the universe of possibilities, yes.
But for an individual to be subject to general jurisdiction, do they have to have some sort of reside here at some point, or can they just make enough trips to Florida that then they are subject to any lawsuit whatsoever?
Certainly, that's the second prong of the Venetian salami analysis. That if the plaintiff pleads the sufficient predicate facts to come under the jurisdiction of the long-arm statute, that's the threshold inquiry that the court has to make. But then, second, if the court gets past that, and the courts here did not, then we have to analyze the issues from a constitutional due process and whether there are sufficient minimum contacts. So yes, that is generally possible, but there are rules and things that have to be met in order for that to happen. But all of the facts that I just went over show that these are exclusively New York operations. They are not Florida operations, and there is no purposeful availment of the Florida forum by these New York defendants. I went over the Venetian salami arguments, and certainly those are applicable here. The parties seem to reference the same general authorities for the contextual interpretation here. That's the advisory opinion to the governor and the Ham versus Portfolio Recovery Associates case. As my counsel noted in her opening argument, words matter, and that is why we are here today. Both of those authorities that I just mentioned stress the words plain, natural, obvious, and common sense meaning. And like I think your question, Justice Coriel, at the beginning, if you look at the word manufacture, that connotes putting things together that are going to be put into the stream of commerce, like a washing machine, a dryer, a toaster, an automobile. It does not connote the abstract mental thought process that a doctor would go to when he or she is formulating an opinion, which is an intangible concept. That's the supremacy of the text principle. That requires a strict interpretation of words, and I think that this court needs to make that strict interpretation of the long-arm statute for that reason. And looking at the plain words of Chapter 48, 193, nowhere in that statute is there a category of preparing reports, rendered opinions, listed as constituting processed, serviced, or manufactured. It's not there. So taking just the statute on its face, reports are not there. Mental impressions are not there. Opinions are not there. I thought it was interesting, Justice Grosjean, when you presented the hypothetical of a New York lawyer rendering an opinion or preparing a will that is later brought to Florida. I have a remarkably similar issue that's pending before the 3rd DCA right now, only it deals with an arbitration and not a will. So there, the issue of where that report winds up or where that opinion winds up is irrelevant if there is a problem with the advice that that lawyer gives in New York. If there is a problem with the opinion that that doctor gives in New York, then the proper forum is in New York. And that doctor has not made a purposeful decision to avail himself or herself of the Florida jurisdiction. Contextually, as the 6th DCA properly concluded, these things do not embrace simply writing a written document. And I think that has been very clear here today. The statute connotes physical, tangible handling or manipulation of an object as opposed to an intangible or an abstract thought or an output involved in writing a report. The word service. You take your automobile in for service every 5,000 miles. That involves taking an object and adding to it or subtracting to it to keep that object moving. It does not involve an opinion or a thought from a doctor.
Does products liability law in general extend to intangible products like software and that sort of thing?
Certainly, I think the intent of the statute as it is written would involve a physical, tangible product. But
let's say he was asked, Justice Tannenbaum was asking about levels of abstraction and generality, and one way to look at this, and I think there's some historical kind of contextual type evidence that this really was meant to get at products liability.
Yes.
But I'm just wondering, products liability, though, isn't just limited to tangible things like washing machines.
Right. Consider the software in my car. If the software in my car, if my car has self-driving capabilities and it causes me to veer off the road and get injured, presumably I would have a cause of action if the software was defective, right?
Yes.
Okay.
Yes. So that software is.
So I guess so if we assume that the concept of products liability is broad enough to include that sort of thing, then why, I guess, can you just kind of talk through why?
Sure.
You can't, it seems like you can't over rely on the fact that it's not like that the report is the result of a mental exercise.
Yeah, certainly. No, I do have some experience with that very issue, Your Honor. And that software is incorporated into a product, into a car. And you have the entire entire product, the entire finished thing that is defective and that causes the accident. So in your hypothetical, if your physical vehicle uses that software and on the self-driving feature drives into a police car, then there is a products liability cause of action because the entire car is the product in that case. So I think
presumably though,
What about in, yeah, go ahead.
presumably though, like I would argue the software is defective. There's no defect in the in the toaster or in the washing machine as you've articulated it, right? It's not a mechanical failure.
Certainly, but it is incorporated into one larger project and a product, and that proves that shows the point precisely. The more that you have to labor to put that square peg in that round hole, the more that statutory definition does not meet the common, the ordinary, the natural meaning of the word.
Well, you can go one step further. So if we're going to do an originalist approach to the statute, so the statute was adopted, 1973, in the 70s, and if we're going to look at, thing at the time could not have included software because it didn't really have, we had it, but rudimentary, not the stuff that we're talking about now.
Sure.
What should we be reading what was understood to be products liability, or the stuff that was going on? Stuff is another broad word. What was going on at the time in the 1970s, or is this is this a concept that is plastic enough to evolve and accommodate new developments and, I don't know,
certainly
products?
Certainly the law is ever changing and evolving, but
do statutes evolve on their own, is my question.
Statutes are written. They're abstract concepts written, produced.
Things.
Things. They're things. Everything is a thing.
Processed by the legislature.
Everything is a thing. They are the mental outputs of the legislature.
I mean, even love is a many-splendored thing, right?
Exactly. So I think the answer is the more that you need to move away from the plain, the natural, and the obvious meaning of the word, the more you go astray, and the more you get into territory where it is overbroad and it is not what the legislature intended. So, and I think that is very applicable here. The petitioner relies on the Dean case from the first DCA for many of their arguments, but that is remarkably factually distinguishable in this case. There, the patient was a Florida citizen. Here, we have the petitioner. She was a New York citizen at the time of the treatment. In the Dean case, Dr. O was a Florida licensed physician. That is a fact that is absent from our case here. Dr. O subjected himself to Florida regulation for the practice of medicine. That is a fact that is absent here. Dr. O had extensive ongoing ties with Florida. He treated over 3,000 Florida patients a year. That is absent here. He actively
Are you arguing against conflict jurisdiction by distinguishing Dean, or?
What I'm saying is the first DCA case of Dean is factually dissimilar, although the issue that the courts in both the first and the sixth ultimately came to is the same, which brings us here today.
Right. I mean, the question is a medical record a thing that's processed that would satisfy the long-arm statute?
The sixth DCA indicated that it was a thing, but that I don't think that it is processed in the context that we are here today for.
So do you think, so if the statute had said products, materials, or things created, processed, serviced, or manufactured, would you lose?
I'm sorry, I didn't hear your question.
If the statute included the word created in that list, if it said created, processed, serviced, or manufactured?
That is...
you would have to, right?
That is a fact that we don't have right now, but...
I guess, is the statute really that much different than if it had that extra word in there? Unless you kind of look behind the words to a more you find limits more sort of in terms of like what work is this really intending to do? Is it really a products liability thing that's sort of filling that niche within this broader statutory structure?
I would submit that the addition of the word created in the context of serviced or manufactured would be a products liability issue, because we have to take all of the words together. There are no surplusage words, and if you read processed, serviced, created, or manufactured, to me that indicates that you are taking constituent parts and making a different product.
Whereas authored you would concede to be a problem for you.
Authored would be a different situation, yes. Yes, and that is something that we do not have here in this case. So it appears that the Dean case, the court issued its opinion mainly on that second prong of the Venetian salami analysis, and not necessarily the first prong with the long-arm jurisdiction. In the conclusion on the very last page, the first DCA said, there were sufficient minimum contacts by Dr. O within Florida to satisfy constitutional due process requirements. It doesn't specifically address the issue of the long-arm statute. So I think that is just another issue that makes Dean both factually and legally distinguishable from the case that we have here. And in addition, Dr. O owned real estate rental properties here in Florida. Again, another fact that we do not have here. So the last point that I wanted to make was that in the petitioner's second amended complaint, there's no allegation of temporal causality. That was indicated as an issue both at the trial court and at the 6th DCA. Judge Brownlee said she would have granted the motion to dismiss on that basis alone. But there's no allegation of that temporal causality because it does not allege at or about the time of the plaintiff's injury. So as to the petitioner's argument that amendment is necessary, we would argue that that would be futile at this point based upon my previous arguments. So given all that, Your Honors, we respectfully request that this court affirm the 6th DCA's opinion and reject the 1st DCA's opinion. Doing that would foster uniformity across the DCA's. It would curtail jurisdictional overreach. It would shield out-of-state medical providers from providing unforeseen Florida litigation, and it would provide Florida citizens seeking medical care out of state with more treatment options.
Okay, thank you so much.
Thank you very much, Your Honor. Appreciate your time.
The Florida legislature knows how to limit language and how to accept language, and could have written except for professional services or except for medical reports. It didn't do that here. It has a very broad term that's things. Justice Curiel, you're right. It is a very broad thing. We can use it anywhere. But what you have to look at is process. And I urge this court to do as the 6th District Court of Appeal did. Go to Merriam-Webster Dictionary. Processed is a transitive verb, and it leads you back to the word process. All that the 6th District Court of Appeal didn't do was close that loop. If you go to Merriam-Webster and you look at the word process, it's defined as a series of action that produces something.
But isn't it kind of an unnatural, I mean, just to pick up on Justice Coriel's analogy, I mean, you don't really say that authors process their books, do you? When you're talking about the act of, writing
I did
it.
process my brief. I processed my brief by my partner reading it, my paralegal
do you come
helping.
home and tell your family, I processed 3 briefs
It's not the
today.
vernacular that I generally use, but it is what it fits.
Isn't that really what we do with statutory interpretation? Does this flunk the Scalia cocktail party test that if you used it in a weird way, you'd get a weird look from people?
Scalia and Brian Garner would maybe say that they processed briefs.
So Merriam-Webster says a series of actions that produce something or that lead to a particular result.
A report. That is it. It was a report that was processed, and it meets that. The Florida legislature did not see fit, nor should this court infer or add a limitation that is not in this statute. I'm going to run out of time, so I want to make clear, if I hadn't already, the 6th District Court of Appeal did not reach that second prong and deferred, just said we're not going to the Venetian salami test of prong 2. It wasn't reached. So my request and relief from this court is to disapprove the opinion of the 6th, remand so that the second prong of the due process prong can be addressed, and approve not just Dean, which is identical. If you read, counsel and I disagree, if you read the Dean decision, section B, it is spot on, written report and analysis. And so it fits this case. We ask that you approve Dean and the 4th District Court of Appeal Thomas Jefferson case. Justice Curiel, I've got the sufficient minimum contacts. You just mentioned them, the 3 agreements. There's a $430 million building sitting in Coral Gables. There is definite purposeful availment of Sloan-Kettering here in Florida and its doctors. So we would like that opportunity to prove that at the 6th District Court of Appeal level. And thank you for your time today.
Thank you very much. We'll be in recess for 10 minutes.
This honorable court is now in recess.
I have something.
All rise. Supreme Court of Florida is now in session. Please be seated.
Okay, our last case today is Alt versus State of Florida, number 2024-1018.
May it please the court, Logan Mose on behalf of Howard Stephen Alt. With the court's permission, I'd like to reserve 5 minutes for rebuttal and response to the cross appeal. Your Honors, in this case, I have raised 10 issues. 7 of those are more general challenges to the death penalty that have been argued by other defendants already. So rather than retread old ground, I'd like to focus today on issues 1 and 3, both of which are unique to Mr. Alt and the way his penalty phase was handled. But before I get to the meat of those issues, I wanted to address a broader point. Just as in the trial court, I of course recognize that Mr. Alt's crimes were horrendous. But there was also, in this case, substantial mitigation that convinced 3 out of the 12 jurors to vote to spare his life. And it's noteworthy that over multiple penalty phases, a quarter of the jurors consistently were persuaded by the mitigation presented. The state has described this case in its brief as highly aggravated, but it was also highly mitigated. And we, of course, cannot know what any particular juror was thinking, but it very well might be that without the impact of the errors, a couple more would have ended up leaning in favor of life over death. And this is perhaps best seen when considering issue 1. The prosecutor below argued if he were to be sentenced to life for the murders of these girls, he suffers no additional punishment. He might as well have been found not guilty. This statement turned a non-statutory mitigator, which is absolutely permitted, into a non-statutory aggravator, which is forbidden. Mitigator 43 was that Mr. Alt was already serving a life sentence based on a plea in another case. This was relevant because it showed a desire to stop his compulsions and be prevented from harming another child. He made the choice in that other case to say, I've done what I've done, it is terrible, I don't want the opportunity to ever do it again, lock me up.
Can you answer the state's response to that, which is, in the context of weighing aggravators and mitigators, it is permissible to engage in a comparison of outcomes and perhaps help us draw a line between what you say a prosecutor could have said about these facts and could not say?
So I think the major issue is that a prosecutor absolutely can discredit a mitigator, they can minimize a mitigator, they can do everything they can to bring the weight of a particular mitigator to 0. That is acceptable.
How isn't that what happened here?
Because what happened here is the prosecutor, if we're talking bringing it from a positive to 0, the prosecutor here brought it negative. They put it on the other side of the scale. A mitigator can mitigate, or it cannot, but it cannot aggravate. And the prosecutor here went too far. The simple statement of, ladies and gentlemen of the jury, ignore that other case. We don't care about that. What we're here is for justice for these 2 girls, and that, in this case, the aggravators make him worthy of death. If that had been the prosecutor's argument, issue 1 would not have been raised.
But the jury, the jury knew that he had a life sentence, right?
They did.
Right. So whether the prosecutor mentions it or not, they know that the consequence of just getting another life sentence would really not make a difference. If that was, if that's what they're going to start considering, and whether they're going to consider his plea as a mitigator as opposed to a nothing.
They might have known that factually, but it's entirely different between, or there's a large difference between knowing that something is true and being told and emphasized that that thing is a reason for death. That's the problem here, is that the prosecutor gave this as an affirmative reason for death rather than simply said it's not a reason to give him life. And that emphasis, that direction, is a problem. And this court has actually recognized this. I don't believe it's ever been faced with this head-on in this same posture, but in the very recent Jackson case, which the state filed a supplemental authority last week, the court reiterates something that it first said in Cruz versus State. That wasn't Nicholas Cruz, it was a different Cruz, for the proposition that the prosecutor, or the emphasis there was that the comments made were not erroneous because the prosecutor did not label the mitigation as aggravation. That was a reason why the comments were fine, because the prosecutor did not do that. Whereas here, that's exactly what the prosecutor did. They labeled this mitigation as aggravation. It was not simply disregard that. It was, here is a reason that you should decide that Mr. Alt be executed.
How would you distinguish it from what we described in Lloyd v. State a couple of years ago? Lloyd?
Could you remind me of?
Lloyd was where they, I believe, the prosecutor stated that the defendant had received life sentences for 2 murders, 3 attempted murders, and then basically asked the jury if another life sentence would even be appropriate in that case. Defense objected, and we said that that was not enough for a mistrial in that case.
I think there's a difference between asking the jury whether life would be appropriate and telling the jury that death is the appropriate option. I think that Lloyd pushes the boundary. I personally think that it probably went too far, but respecting this court's precedent, I think that it is shy of what was said in this case. I think the large part of this case that makes it even worse is he might have been found not guilty. It's not just talking about what sentence is appropriate. It's getting into this idea of, why are we even here? Why are we wasting all our time? There's no justice if you do this. That's the sentiment that was being conveyed by the prosecutor. And what really should have been done is simply focus on this case.
But isn't that the sentiment expressed in the aggravator for a prior felony and a sentence imposed? Isn't that suggested, and isn't that part of the aggravators? Okay, this guy has committed a felony in the past and was sentenced to something, and apparently that wasn't good enough, and so now we have this capital murder, and so that elevates it.
That perhaps could work if it had been a situation where, well, certainly if he's sentenced and then is no longer in prison and then picks up a new crime, which is the facts of this case, but not with that particular event. Or maybe even if someone is sentenced to life, they're in prison, and they commit another murder while in prison. Here, though, the crimes and punishments it was crime, crime, punishment, punishment. So it's not an idea of he didn't learn his lesson or anything like that. It's, well, he pled guilty, which that's a whole nother aspect that the brief gets into of exercise of rights. But he pled guilty, he's got a life sentence, so now on this case, clearly we need to step it up when there's no intervening decision on his part that would serve as an aggravator. It's also worth noting...
wasn't this used as an aggravator, or am I mistaken? This prior violent felony?
There were prior violent felonies that were used as aggravators, but there's a difference between the prior violent felony being used and the sentence for that prior violent felony. The fact that someone has a prior act of violence, or the way the statute and case law works out, a contemporaneous act of violence, is different than saying the sentence on one requires another sentence. So imagine this case if the prosecutor had said, look, you have two crimes here that you're deciding. If you decide life on one, well, you better decide death on the other, because that second crime wouldn't matter then. It's essentially the same framework as here, where we're just looking at a different crime. You can use one to aggravate the other, but the sentence that's given on one isn't an aggravator, and it's a non-statutory aggravator, which goes against what the statute requires. So the statute obviously asks whether the aggravating factor exists, and then it requires the jury to weigh whether aggravating factors exist. That's A. Whether these aggravating factors outweigh the mitigating factors, that's B, and then based on the considerations in some paragraphs A and B, whether the defendant should be sentenced to life imprisonment or death. Clearly, what C and A and B are referring to are the aggravating factors. The only thing that can justify death is an aggravating factor. Nothing else can justify death other than an aggravating factor. And here, the prosecutor used the prior life sentence, or the currently serving life sentence, as an aggravator when that is not part of the statute and is not permitted. So that's the fundamental problem with issue one. It's not even necessarily that it's a conversion of a mitigator to an aggravator. I think that makes it worse, but it's that there is a non-statutory aggravator being used to impose death. I also want to briefly discuss issue 3, which is the issue of Dr. Eisenstein's testimony. So at no point during Dr. Eisenstein's testimony on direct appeal did he discuss the facts of this case. That was not what he is an expert in. It is not, he has no firsthand knowledge of them. That was not the point. Dr. Eisenstein's testimony was a discussion of the frontal lobe and prefrontal cortex in the abstract, and then as applied to Mr. Alt, explaining that these controlled one's ability to decide right and wrong and whether an action was appropriate or not. He never said that if you have deficiencies in these areas, you can't make basic plans, you can't know cause and effect, you can't do things. It makes life more difficult, especially because we expect morality of people in our everyday interactions. But when they act, they are doing so without a filter. It was looking towards Mr. Alt's ability to think through his actions before doing them in a moral sense, not in a cause and effect, can I get my outcome sense. But then on cross-examination, the prosecutor got into the facts of this case, seemingly implying that, well, he could make basic plans. He, picked him up in his truck and had an idea at that point what was going to happen. But that is a completely separate issue than what Dr. Eisenstein was talking about. He wasn't talking about, well, can you decide I want X, here's how to achieve it? It was, I want X, and then the step back that we all are supposed to take of, is X something I should want? Oh, no, it's not. I'm not going to do X.
But isn't that up to, in the course of a trial, so an expert takes a stand and the lawyer putting him on the stand does direct and they elicit opinions. Can opposing counsel then test that opinion by proposing certain facts? Did you consider this fact or this fact? And how does that change your opinion? That kind of thing. And then it's up to the lawyer who put him on the stand in the first place to clean up the opinion by clarifying, well, but that isn't relevant to your opinion or something like that.
I think that defense counsel perhaps could have done that, and that would have been advantageous to the defense. But I think the problem here is simply that that line of questioning should not have been gotten into because that wasn't Dr. Eisenstein's expertise. If Dr. Eisenstein had testified or had there been argument made or anything relating to he can't have thought through the results of his actions and therefore he had no idea what was about to happen when he picked them up.
Was there an objection during the cross-examination?
The objection, yes, there was an objection to beyond the scope of direct. It was specific.
But not as to the expertise, correct?
No, but they're one and the same in this context. Is the expertise was the topic of direct, and so if it's beyond the scope of direct, it is also beyond the scope of his expertise. I agree perhaps another objection could have helped there, but I think the beyond the scope of direct conveyed the necessary idea that this was...
I guess I'm having a hard time understanding how it's outside the scope. I mean, he's saying the frontal lobe restricts this ability to make a plan, and maybe he's talking about, maybe not a plan, but he's saying it restricts your ability to stop yourself, your impulses, right? And following through with that, as Justice Tannenbaum has said, is the prosecutor going back and saying, well, if that's happening, how is he able to function in these other ways? How is he able to make plans? How is he able to do that if he has this other issue? It seems to be within the scope of what the expert was talking about.
Respectfully, Your Honor, I disagree. I think that the expert was the prosecutor's questions were about how do we get from A to C, ignoring B in the middle. And Dr. Eisenstein was saying that B in the middle is what a lot of us have and what he lacks. But Dr. Eisenstein never disagreed that he could get from A to C, that he could make a plan and execute it. It was about whether that plan had any level of moral thought going into it versus pure base level animalistic, I have a desire, I get my desire. That's all his testimony was regarding.
Going back to what Justice Kavanaugh mentioned, isn't that why we had redirect examination for counsel to come back and straighten that out?
I don't think that's all that redirect is for. I think redirect...
Well, it was there. Did he use it? Did he clean it up?
He could have, and I think that it would have been better for the jury if he had, but that doesn't... The evidentiary error doesn't go away simply because it wasn't cured later through a different process. There's still the error of allowing the testimony, especially when the testimony is getting into pedophilia, which Dr. Eisenstein said he has no knowledge of. When it gets into grooming, which was, number one, misdefined, as well as Dr. Eisenstein saying, I have no knowledge of that. These are loaded terms that were given to the jury through an expert who had no expertise and had no business talking about them.
That was his answer, though. He said he didn't know. Right? He said he wasn't an expert. He couldn't talk about that.
Right. And then the prosecutor decided to define the term for the jury and then ask him whether he did, and then ask Dr. Eisenstein whether Mr. Alt did the thing the prosecutor just defined, which he said yes because he had read the reports.
And was there an objection to that?
That's where the beyond the scope of direct objection was, yes. I see I'm into the time I wanted for my rebuttal, so if there are no further questions. Thank you.
Thank you.
Good morning. May it please the court, Leslie Campbell with the Attorney General's Office on behalf of the state. With respect to issue 1, this was a proper comment. It was discussing the weight that should be assigned to one of the 50 non-statutory mitigators that were offered by the defendant in this case. It did not manipulate or misstate any of the evidence. It did not implicate any other rights by the defendant. It was a comment that was responsive to the defense, which was whether or not this mitigator applies. And the jury instructions clearly informed the jury what it should do with mitigators. And the evidence in this case is overwhelming. The defendant went to a park several days before he actually abducted the children. He made contact with the children on the first day, brought them home, made himself available to the children, made himself available to the family, offered the family who was living in the park, and offered them a place to shower. So he made multiple contacts with these children. And then on the day of the abduction, he went to the school, or just outside the school, picked them up, brought them to his home with the explicit knowledge that he wanted to rape and then he was going to kill these children. With the other child, the one that was at issue here for this mitigator, he had done contact with her earlier, then made sure that the father was approved of her babysitting, and then he proceeded to rape her too, although he said that she should tell. So it was a proper comment on how that mitigator applies to the actions of the defendant in this case and how it should impact whether or not there should be a life or death recommendation. And even if the comment is found to be erroneous and there should have been a curative, this was clearly harmless beyond the reasonable doubt. The mistrial was proper. Turning to the third issue, unless there are any other questions on the first issue. Turning to the third issue, there is a preservation issue. There was not an objection to that the state attorney could not talk about the facts of the case. There was not an objection to whether or not the state attorney could define grooming for Dr. Eisenstein, who himself asked for the definition of grooming, and Dr. Eisenstein, there wasn't an objection to Dr. Eisenstein not being qualified to talk about grooming.
Could counsel's objection sort of being beyond the scope of direct, it may not be the most precise or accurate objection, but was it enough to really object to the state using the expert as almost like a conduit to get facts in front of the jury just by reciting, stating these facts for knowing that the expert's not going to be able to opine on that? Was that enough, or do you have to be more specific? Like, Your Honor, counsel's trying to get these facts in front of the counsel's testifying, basically.
The objection was not sufficient. The whole point of cross-examination is to evaluate how this particular expert looked at the entire case to develop his opinion. So beyond the scope is not sufficient here. Moreover, he's being put. Dr. Eisenstein was put in the place, in the position to tell the jury why Mr. Alt couldn't carry out his crimes and the purpose for his crimes. He's saying that he has a frontal lobe problem, and it is clearly within the state's, or cross-examination in general, the purpose of cross-examination, to explore that. And in order to explore it, the facts of the case were necessary to be examined not only by the jury, but how Dr. Eisenstein handled those facts. Again, if it were error, it's certainly not fundamental error. The jury knew and had testimony on all of Mr. Alt's prior interactions and crimes with other young children, and the jury knew Mr. Alt was convicted of this crime, had been spending time in prison, and therefore whether or not Dr. Eisenstein should have been allowed to answer whether or not this qualified as grooming and was a challenge to the opinion of whether or not there was a frontal lobe damage that exceeded Mr. Alt's ability to commit these crimes. Again, there's no fundamental error, and it was a highly aggravated case, but more important, the trial court found that not only was HAC and prior violent felony proven, each alone was sufficient to overcome any mitigation that was in this case. If there are no other questions on that issue, I'll quickly mention we're asking, we filed a cross appeal, and in that we ask that if the court decides to reverse and sentence, remand for resentencing, we ask the court to find that the age aggravator for the second child, for the 7-year-old, should be allowed to proceed. The aggravator was offered twice before, and it was in the notice of death penalty, notice of seeking the death penalty. The only difference is in the heading for the second child, the proper name of that child was presented, but in the body, when it was describing each aggravator, the state made a scrivener's error and put the first child's name as part of the age aggravator. So we would ask that this court affirm, but if the court reverses, that our cross appeal be considered.
Thank you very much.
Your Honors, if the evidence was so overwhelming, then why has this case been 9 to 12 repeatedly? The state also said there was a knowledge that when he picked up the children, he was going to rape and then kill them. That is not what the evidence in this case showed. There is no evidence that at the time of the abduction there was a plan for murder. The evidence shows...
You dispute that there was sufficient premeditation for first-degree murder?
We're not disputing that. We're not dealing with the guilt phase in any way. But that premeditation developed later, not early on in the plan. On issue 1, the state again is saying that this is about the weight to be assigned, but it's not only the weight to be assigned to the mitigator, it's which side of the scales that weight falls on. If all it is about the weight, we're fine. But it only gets to be on the mitigation side, not on the aggravation side, and that is the problem.
Was there an instruction to the jury telling them how they're supposed to look at the aggravators and the mitigators?
The instruction to the jury was essentially the statute as I read it out. I think that coming as the closing line to the state's closing argument, it's impossible to realistically think that something so mind-warming of he might as well have been found not guilty didn't play in regardless of what the instructions were. It is the sort of thing that eats at someone, and it's hard to believe that any of the 12 didn't think about it in the back, let alone that maybe that swayed 1 or 2 opinions. Justice Tenenbaum, I do think you were right on the preservation on number 3. It was inartful and could have been expanded, but it was enough. But there's more wrong with this because this is where the term grooming came from. The state argued that everything he testified to had come out through other witnesses. That's not true. This is the only place where this incredibly loaded term, especially to a layperson who hears it on the news, who he sees it on Facebook, that's an upsetting term to hear. And to have it come out through this witness, not even through this witness, through the prosecutor questioning this witness and him just saying, what do you mean by that? When that is completely beyond the scope of what he testified in direct, that's a problem. The state relies on the trial court's findings regarding the aggravators. The issue here is what the jury thought, not about the trial court weighing. And as for the cross appeal, as I argued in the brief, it is not yet ripe at this time. It can be argued later. We urge this court to reverse and remand, if not for a life sentence based on the general opposition to the death penalty procedures, at the very least for a new penalty phase. Thank you.
Thank you very much. We're adjourned.
All rise.